Thank you very much. I'd like now to introduce Peter Winn, who is Assistant U.S. Attorney for the United States Department of Justice since 1994. He was also a Special Assistant Attorney General for the Texas Attorney General's Office and has been in private practice previously as well with corporate law firms in New York and Dallas. He's taught privacy law, computer crime and healthcare law at the University of Washington Law School. He received his JD from Harvard Law School and a BA from Williams College. And then he studied philosophy at the University of London as a Marshall Scholar after that. And we present to you Mr. Peter Winn.
Thank you very much. I always begin these talks with the standard disclaimer that the views that I express are not the views of the Department of Justice, but they're my individual views. I think that will become pretty clear in about 10 seconds when I start talking. Thanks for the introduction. I did study philosophy before I went to law school. And when I was studying philosophy, we all learn all these different philosophical theories about ethics. And it's all complicated, and you're slicing bologna all this in thin ways and so forth. But when I started to practice law, particularly when I started to be a prosecutor, first criminal case I had, an agent showed up 2 days before the trial was going to start and said, I just found this document, and I looked at it, and it really hurt my case really badly because it was exculpatory to the defendant. I don't like losing cases, even though we work for the Department of Justice. We tell everybody that we're interested in doing the right thing. Justice is served no matter what happens. We don't like losing. So there's a rule, an ethical rule prosecutors are under, that they have to disclose exculpatory evidence to the other side, to the lawyer who's going to use it to beat me up. Okay, so what do? And first, of course, you're looking at it, and well, is it really exculpatory? Does it really have to be disclosed? Well, does it hurt me? Yes, has to be disclosed. That's the test. Very easy test. Does it hurt you? Disclose it. If it doesn't hurt you, you're probably going to disclose it anyway. Okay? I'm using that because I don't want to be presumptuous in telling a bunch of doctors about ethics and medical ethics. But I can talk about legal ethics. If it hurts you, disclose it. It's not complicated. Okay, so we've already had Dr. Fruhoff talk about Hippocrates. And what is Hippocrates basically up to? He's kind of the guy who came up with the whole notion of medical professionals. And what does a medical professional do? Or what does any professional do? Well, what do I have to do when I discover braiding material on the eve of trial? I have to act in somebody else's interests. I don't act in my own interests. I act on behalf of, in this case, on behalf of the defendant. Okay? Because the defendant's entitled to a fair trial. And my duty as an officer of the court is to make sure the defendant gets a fair trial. Doctor's duty, and Hippocrates was really you can read the various volumes, but at some level, the ethic that goes through Hippocrates is you focus on the patients. You focus on what's in the patient's best interests first. Now, my talk is supposed to be on the anti-kickback statute in the Stark Act. Well, and that's a pretty complicated area. And I have a real simple response to anybody with a Stark Act or an Anti-Kickback Act problem. Or for that matter, a fraud and abuse problem. And that response is the same response that Hippocrates would make. Is what you are focused on, are you really focused first and foremost and exclusively? Is your loyalty focused on the patients? If your loyalty is 100% focused on the patients, which is your duty as a medical professional, you can't get into trouble with me. You know, the only way you're going to have a financial problem is if you screw up the billing. And this, you know, billing's complicated, everybody knows that. But that's just a screw up. It's not something you're going to be doing on purpose. And that's not a crime. It's not fraud. It's not going to get anybody into any more trouble than having to sort out the accounts at the end of the day. So stay out of trouble. You follow a simple rule. Focus on the patients. Now, I've been trying healthcare fraud cases since really before 1994 because I worked on healthcare fraud cases at the department, at the Attorney General's office at the state level. And one of the things that I've noticed over the years is, you know, my first healthcare fraud trial involved a doctor, a psychiatrist, who was billing more hours than there were in a day. Patients weren't being told that he was diagnosing them with depression, and he was billing them for psychotherapy behind their backs. All right. Yeah, I thought this was a pretty good case, you know. Went to trial. The jury, it was a 3-day trial, and the jury was out 3 days. This was in the early 90s. And when, you know, eventually they convicted. But I found out in the initial deliberations there was a majority of the jury voting to acquit, and just some strong jurors that pulled them around. Now, what was happening? Well, the jury just didn't want to believe that a doctor was going to sell his patients out. Okay? Now, a few years ago, actually, the last doctor I tried was about 2002. I had a 45-minute verdict on a 2-week trial. Okay, the jury pools that I polled, juries are juries themselves have been deselected, so they're no longer a statistically valid sample. But a jury pool, which is the group of people who come into the courtroom that you deselect from, are 50, 60 people from the community, randomly drawn from driver's licenses and voting registration records. That is a statistically valid sample of community. And I've tried medical cases in Dallas and in Seattle, which are very, very different communities in terms of one's a blue state, the other's a red state, and so forth. The jury pools are exactly the same. And in the jury pool selection process, you'll ask a question of how many people have strong feelings about doctors, strong negative feelings and strong positive feelings. And in the beginning of my trying these cases, it was very unusual to have negative perceptions about doctors. At the end, you know, a third of the jury pool would raise their hand when they got that question. And every single one of the people who raised their hands had negative feelings about physicians. It shows in terms of the time on my verdicts. The medical profession has lost a huge amount of trust. And something needs to be done. And the reason, I think, is very simple. Why did you go to medical school? If you wanted to make money, you would have gone to go work at Goldman Sachs or something, okay? Now, they're not having a particularly good year, but the idea is if you were really interested primarily in making money, you would not have gone through this agony of the kind of educational process you've gone through. Why do you go into academic medicine and go through another round of agony? Because you care about the patients. You care about science. You care about the truth. Now, when I do both criminal and civil cases, and some of the civil cases I do involve the qui tam statutes. These are the whistleblower statutes that allow snitches to make money by snitching people off, okay? There used to be sort of this unwritten rule. I never, ever would see a doctor as a snitch. The last 4 cases that have been filed in my office have involved physicians who have been very concerned about what has been happening under their eyes and have brought very significant, important cases to me because of their concern. So there are groups of, and frankly, when I've spoken, my sense is the vast majority of physicians are not wrestling with their consciences and losing. But a significant percentage are, and it's like ink in a glass of water. It affects the way the public views the entire profession. And it corrupts the perception. I mean, it makes it, it really destroys the very core of what it means to be a professional, which is loyalty to somebody else, not loyalty yourself. Now, I want to say, when Dr. Kane was talking about clinical trials, when I went to law school, and I just never ever thought I was going to be studying clinical trials in order to be able to explain these things to juries, to put somebody in a situation where their liberty was going to be taken away from them. But that's the last, the last few cases I've been working on have all been involved in clinical trials. And I'm not here to criticize Chad's company. Chad, to some extent, I think, is in the job of herding cats, and is charged with trying to get folks to sort of listen to their better angel. But there are 2 kinds of problems I see in clinical trials. The first kind of problem, okay, you got a clinical trial. Is the device or the drug that's supposedly being tested, are you getting it for free, or are you actually being charged for it? You're going to bill for it. Are you getting bounties for the patients? Are you getting paid for lining up patients? Now, I'm not talking about the study budget. I'm talking about, you're getting $5,000 for every patient you line up. If you are, is that being disclosed to the patient on the patient consent form? Why not? Is it material to a patient's decision whether to engage in a clinical trial, whether or not you're being paid a bounty to line them up? Well, most patients would say yes. So why is there a resistance to disclosing that to the patient? It's kind of like the Brady issue, isn't it? You don't want to disclose it because it's going to hurt you. Well, that's exactly why, 1, you probably need to disclose it, and 2nd, you may want to think about, and many academic institutions have simply taken that whole bounty thing off the table. You just may want to think about not letting that be part of the game in the first place, because it creates an appearance problem, and as Oscar Wilde famously said, only shallow people don't judge by appearances. Now, is it real research, or is it marketing? Is it a phase 4 study of something that's been looked at forever? And, and then, lo and behold, you're really either billing for the device or the drug, or you're billing for a related drug or device that's part of the study. Ask those questions, for goodness sakes, because you don't want to be seeing me. The other problem about clinical trials is of a more recent origin. And that's the kind of stuff Dr. Kane was talking about. All of these issues that he has raised, are there multiple endpoints? So you can just kind of pick and choose and see whether anything pops up at the end of it. Is it a retrospective study or a prospective study? And when you read the article, is it clear? Does it disclose? Is a retrospective study really being presented in the article as a prospective study. Are you manipulating the patient population, either at the front end or the back end? Are you manipulating the dosage? I never thought I would have to sit down and read these darn articles and try to figure out the medicine and then try to figure out how to become skeptical about the medicine. But a lot of physicians who have been very concerned about this issue are starting to spend time with prosecutors because it's fraud. That's the bottom line here, and you go to jail for fraud. So don't think this is just like a bunch of scientists talking about ethics, because you'll be up before juries at some point when you screw around with that. And the juries are going to be not the juries that I was trying cases before in the early 90s, but the juries that now have lost the trust of the medical profession. A lot of the off-label stuff that's going on is problematic. Technically, a medical device company, drug company, isn't supposed to be even marketing or promoting these drugs. Obviously, they want to give you the medical research and the literature to show that this stuff works. But that whole research area is, the concern is you start reading that literature and you start reading those hard questions that Dr. Kane is asking, sorry. And if you see that this is research that's being, that's problematic, operators are standing by. There is a statute that says you can recover up to 30% of the recovery that the government makes for showing that people have been tricked into doing something that they otherwise wouldn't have done if they'd known the truth. And that's how a lot of these cases come into our offices. I'm gonna stop talking for a second, but again, I want to leave you with this thing, which is this one sort of simple truth. It's kind of like, I was going to be a parent, and I bought a copy of Dr. Spock. And I read the book, and the introduction of that book is just wonderful. And Dr. Spock says, you've got all these books about child care that people have written over the years, and it seems so complicated. At the end of the day, you know more than you think you do about raising kids. And of course, you do, because parents have been raising kids for years, since kids have been around and parents have been around. And you focus on the best interest of the kids. You focus on the best interest of the patients. No way you're going to get into trouble if that is your exclusive loyalty, which it has to be if you're going to be a medical professional or any kind of professional. So I'll leave you with that, that one test. Is your exclusive loyalty focused on the patients? And if it is, you're safe. But if there's money floating around that infects that loyalty, then there's going to be some problems. Because human beings are, we have good side and a bad side, and we're all subject to temptation. And when that money's flowing around, that's going to get us into trouble. And it certainly got the medical profession into trouble, and the juries have noticed. So I'll leave you with that. Thank you.